Hello, my name's Elizabeth Charity, and I am the CEO of Youth Corporation Inc. I want you to share with me exactly what you are doing out here today.
What we are doing is called an event called Gas on God.
Free gas on God!
We have a faith leaders membership partnership with the police department. There was a fund that was created, over $1,000, and people in this community, we're at Chamberlain and Brooklyn Park Boulevard, are getting gas on God, gas for the faith leaders. We are pumping gas, we are giving resources, and we are providing prayer. Come on out, come on out.
Hello, Lomacio here, Creative Director of YCI, Youth Corporation Incorporated. In this episode, we're exploring reforming the criminal justice system. In this episode, Kelly Burnett and Iman Shabazz from the Commonwealth's Attorney Office will be interviewed by executive producer Richard Whiteside.
Simply, I want to start out with you giving us your name and your position, and we'll just start with that.
My name is Kelly Burnett. I am a Deputy Commonwealth's Attorney for the City of Richmond. I work for the elected Commonwealth's Attorney, Colette McEachin. I have been a prosecutor in that office since 2004. I worked in the Juvenile and Domestic Relations Court primarily from 2006 to 2021, and I have recently moved to a role leading the newly formed Community Justice Reform Unit.
So tell me a little bit about what that unit is and what its goals are.
The mission of the Community Justice Reform Unit is to critically examine the way that the prosecutors in our office use their discretion to increase, improve, and expand the use of community-based alternatives to incarceration so that we can address mass incarceration, to make recommendations to Colette and the administration of the office about best practices and evidence-based programs that may already exist or may be opportunities that exist for the future, and to make sure that we are trauma-informed in our practice, that we are responding in a way that recognizes trauma in the community, in both our victims and defendants, also in witnesses who have been exposed to violent crime, to other trauma in their lives, and respond to that appropriately and sensitively, keeping in mind the root causes of crime.
As you're rolling this out, what are the barriers that you face, and what are you doing to overcome those barriers?
So it's interesting that you mention barriers, because that's one of the first things that we're looking at in the formation of the unit, trying to identify what barriers may be in place that might be keeping us from utilizing what we already have available to us. Some of the things that we already have available are several specialized dockets. So we have an adult drug treatment court. We have an adult behavioral health docket. We have a juvenile behavioral health docket. We have a adult mental health docket. And these are voluntary dockets where defendants who have been identified as having a substantial issue with substance abuse disorder or with mental health have a way to address those issues within the court system. And so they're diverted from incarceration and they're placed in those specialized dockets. In order to make sure that we have a good fit and that the people who need those services are getting matched with those services, we need information about the defendants. And so one of the things that we're looking at is how can we get more information earlier about the needs that people have and the risk level that they pose, so that we can really make informed recommendations and offers in our cases.
For me and others who don't know what a docket is, could you kind of explain a little bit more what a docket is?
Sure. So a docket is basically a schedule that the court has. And so each judge, for example, every day has at least one docket. There'll be a morning docket, there'll be an afternoon docket. So that's just the judge's calendar where they put their cases on there. And so a specialized docket means that those cases that are identified as having defendants with similar needs are referred to a particular judge, and they are heard together on particular scheduled days. There are also dedicated professionals who provide their services to those dockets. And so, for example, the mental health court or mental health docket, there is a dedicated probation officer, there's a dedicated case manager, there's a dedicated prosecutor, a dedicated public defender. And so all of those professionals are working together to develop plans for the people who participate in those special dockets or special courts.
That sounds fantastic. It sounds like this is the whole court system, defendants and prosecutors trying to work together to find the best equitable solution for a problem as opposed to just pure punishment.
You're absolutely right. And that is what we want to do, because ultimately we want to reduce crime. We want to reduce recidivism. And if we're not addressing the needs of the defendants that we see, then that's not going to happen. There are other programs that are available in the community other than the specialized dockets. And so we really strive to link people to those as well. We have the Day Reporting Center, which is a program run by the city that's an alternative to incarceration. And then through probation, there are also other services that probation officers can refer to, like Richmond Behavioral Health Authority, or various community organizations that can help address needs.
What are some of these? You mentioned a couple of them, but I kind of like to learn a little bit more. What are these specific specialties that are being set up to follow? Does that make sense?
Well, so the two main issues that we currently address through specialized dockets are mental health and substance abuse. And sometimes those are co-occurring, which means both are happening. It's very common that we see, especially in juveniles, for there to be a mental health issue that then they're self-treating with substances. And that happens in adults as well. It just a lot of times begins with the juveniles. And so those professionals who work in those dockets are aware of those dynamics and those issues, and they're trained to identify them. And so what happens is if someone is identified as a good candidate for those special courts, then they'll be referred for an evaluation to make sure that they are getting matched with the appropriate program. One of the things that we have in the juvenile court, where I worked for 15 years, that we don't have in the adult system is a court service unit. And that court service unit serves several functions, but one of the functions that they serve is as an intake. And they assess the needs and risks of defendants when they come in to the court. And so they, on the front end, are gathering information that we don't really have in the adult system. So we then have to do our own legwork as prosecutors in the adult system to try to find that information because no one presents it to us in a packet with historical information about the defendant, or what their treatment history is, or what their substance abuse issues are. We have to try to get that through law enforcement, through defense attorneys, through maybe if they have a history with us, things we've seen in the past, through information we know about what the incident was that brought them to our attention and caused them to be arrested in the first place. So when I say that some of the barriers are about getting information, it's really because there's nothing set up for us to have that on the front end. The way that the criminal justice system has been set up to work is adversarial in nature. So the information and the investigation that's done about the defendant and their needs and risks historically has been done before sentencing. So you have a trial process or a plea process that resolves the charges, and then you ask questions about what the defendant's needs and risks are. What we really want to have is that information much earlier so that we can make more informed decisions about charging, about needs, about referral to certain dockets. And so identifying how we can get that information earlier on is one of the things that we're doing. Another thing that we're working on is expanding the use of restorative justice as a program. So that's not a special docket or special court like drug court or like the mental health docket, but it does exist as a service in the juvenile system. And so what we've done is we've talked to our partners in the juvenile justice system, the court service unit and the Department of Justice Services to try to get more money to fund restorative justice for more juveniles. Because Colette really feels, and I agree 100%, that restorative justice and the way that it frames incidents of crime is a way to begin healing the community and a way for juveniles to begin thinking about the impact of their actions. But we want that to be in the adult system as well. And right now there's not anything set up. So we're trying to work on making that happen, making it available for adults, because we see cases so often where there are disputes that cannot be resolved, and there's a lack of acknowledgement on the part of the person who's doing the harm, and there's a need by the person who is being harmed to understand, why did this happen to me? What can we do to make this right? How can we fix this relationship or this, in the community? How can we live together and work beside each other in a way that we can do that in a peaceful way? And that's not something that we really right now have an opportunity for, and we'd like to see that. So we're working on that.
Wow, that's fantastic. So is restorative justice meaning looking back at old cases to review it under a new lens and possibly coming out with a different outcome?
No, restorative justice is a principle that addresses the harm that has occurred, instead of looking at a particular incident and looking for a way to punish the behavior of the defendant. And so the restorative justice has several models, but all of them involve conferencing. And so it brings the victim into the process. It brings the defendant into the process. Sometimes it brings other people in the community into the process, into what's called a circle. And there could be many people who are harmed other than victims. So it could be family members of the defendant. It could be business owners. It could be other people who live in a community and have to see graffiti or property damage because it's across the street from where they live. And so the model addresses the harm and the needs of the people who have been harmed. And what we see is that victims many times want more than what the criminal justice system has typically been able to offer them. They want answers. They want to feel a sense of resolution. And in those conferences, whether they're just victim and offender conferences or whether they're group, circle, or conference, then they're able to work out those things and they come up with their own resolution about how can we reconcile? How can we come to a place that we are at peace with what has happened? And that then allows those people to move forward. And so it's a whole other mindset. And restorative practices can be used in lots of ways. They can be used in schools to resolve disputes and conflict. They can be used completely outside the criminal justice system, or they can be used as a tool within the criminal justice system to allow people to resolve the harm, and then we examine that as something that's been accomplished and decide then, well, do we need any more tools from the criminal justice system to address this, or is this good? One of the other things that we want to make sure that we don't forget in our efforts to connect people with services in the community is the importance of due process. And so first and foremost, we have to make sure that we are fulfilling our ethical obligations as prosecutors. And so we want to make sure that prosecutors have the best training that they can have, not only in order to think creatively about how to resolve cases and get good outcomes, but to make sure that we are disclosing all the information that we need to disclose to defendants so that they can have a fair trial. That we are doing our due diligence to get that information from law enforcement, that we are able to balance the needs of the defendant with the needs of the victim, so that we're getting the right information that we need from the victim. So all of those things are paramount, because ultimately there are always going to be people who want their day in court, and they are contesting what happened, or they don't. There's a disagreement about what happened or what the truth is, and those people deserve the best process that we can give them, and it's our obligation under the Constitution to do that. And so, in addition to all of the programming that we're focusing on, this is an intentional effort by our office to make sure that all of those things are in place as well.
My name is Aman Shabazz. I am currently the Policy Advisor for Community Engagement and Reform Initiatives within the Office of the Commonwealth's Attorney within the City of Richmond. That position is newly created over the lifespan of my holding that position. It was uniquely brought into the office in order to be able to create the opportunities to not only affect the culture of the office, but to affect the relationships of those within the office to our community members who are most impacted by the criminal legal system.
So you mentioned that the Commonwealth Attorney is looking to find what changes they can make that have a positive effect. What are some of the changes that she does want to bring forth?
In terms of current, nonetheless, changes, we have been working to really revitalize, I say revitalize, but I should probably just say in all sincerity, institute a robust restorative justice program, certainly within the juvenile and domestic relations court, but to look at the opportunities of how that expands into our school system. I have been working pretty diligently with a number of our persons within RPS, particularly the manager for I may say the title wrong, but the manager for school climate and culture there in RPS. We've worked together for a number of years and have been working to really expand just what those opportunities look like within the context of the school system. And then, of course, trying to really drill down to what are the specific points of intersection with our office. And Ms. McEachin is definitely very interested in making sure that we explore the opportunities for restorative justice, to really be able to try those to try to create those things programmatically that will hopefully allow for preventing folks from even coming in to, as I always say, the courthouse doors. We try to create the space for folks to start dealing with conflict, if you will, in different ways, to really understand what developing methods of accountability really can look like at the community level, and to explore, certainly with the young people, opportunities for creating creative ways, developing creative ways to help give input, in terms of what those processes look like, and of course how they in turn would benefit most from them. We have, in addition, not so much just in terms of what she's doing immediately, we have maintained relationships with RPS where we've gone into the schools, both at the elementary school level, middle school, and high school levels, to really just be able to create a presence and a bit of a road towards clarity in regards to what a prosecutor's office really is. Really trying to create awareness and to raise levels of education around just what this office does affect, and then in turn how to best maximize I'll say the opportunities to, again, be able to assess situations that community members, in this case young people, might find themselves in, and those who are working with young people, and to determine perhaps paths where there are opportunities, again, to divert the path, or perhaps to extract young people in under certain circumstances or under certain situations, to again avoid the potential for having to deal with it in court, to deal with the situation, in court, and to allow those things to create the type of accumulating consequence that will perhaps hit them in the direction of the pipeline that the gentleman spoke of earlier.
You mentioned a robust restorative justice program. Can you explain a little bit more what you mean by like a restorative justice or restorative program?
So restorative justice, just at its core, really means creating the space for the person who, in a particular situation, who has caused harm, and a person who has been harmed, or persons, depending upon the situation, who have been harmed, to be able to come together and to speak the truths, certainly from their own perspectives, about what led to that particular interaction, that behavior, that incident, or whatever is there, and to learn and gain understanding, that is the person who's caused harm, for them to learn and gain understanding of how the person that they harmed was impacted. And from that, you develop a model of accountability in terms of those actions, where the person is not only acknowledging that they, were engaged in the activity or whatever it was that occurred, but that they acknowledge the impact that it actually had on the persons. They show some very serious, remorse, if you will, from how it was impacting the person. They develop a means of agreement between each other in terms of how to rectify the circumstances, and that's the part where I think is really key, because in our general thinking, oftentimes the only thing that we know is the police, is arrest, conviction, and incarceration. Those are the only things that we think are alternatives, that are options for us in terms of resolving conflict. And this creates an opportunity for us to not only use our imaginations, but to really be able to set the stage for changing the culture around how we deal with conflict. And then finally, developing a sense of commitment, if you will, from the person who's caused the harm, not to engage in that behavior again, not to cause the same harm again, certainly not to the same persons, but to anyone. And I think that, you know, as I mentioned, because there's been a lack of understanding of what dealing with conflict at a community level among youth or adults, because there's been a lack of understanding of what that has looked like historically in other cultural contexts, I think that the only thing that we generally do, is to kind of push people towards this punitive model of resolving conflict or of dealing with what we've deemed to be a criminal behavior. I think that's something else that we have to look at as well, because sometimes I think the activities that are engaged in or things that people are brought into our system for may not necessarily hold up as criminal in the context of how they're received at a community level. So, for example, I think you all may be able to relate to this. As young people, there was one point in time where if we had a conflict and we engaged in a fight, we engaged in, some sort of back and forth that got physical, there was a level of understanding, if you will, of where that was an endpoint, to the degree that the behavior wasn't criminalized, but we really, if there were, adults who were thoughtful enough to be able to do so, could, sometimes it was parents in the community, sometimes it was teachers, it was whomever, but who could sit, myself and whoever the other young man might have been down and say, okay, Mom, what's going on here? Why did, what's going, you all, there's a myriad of things that you all could do in order to be able to deal with this, and that behavior is unacceptable. So let's get down to what happened. How do we fix it so that y'all aren't back here again tomorrow in the same space? That existed within our cultures, or various cultures, at one point in time, and it still exists to a small degree in various pockets. But in a mass context, we've moved away from that, where now if I were to engage in that same activity, an officer may be pulled in. The officer, for however our interaction may end up turning out, may end up putting charges on me in addition to what has happened with regard to the dispute that I had with the other student, and then of course you've created this really larger than necessary thing that's brought into a courtroom in order to resolve. Now, I recognize, or I won't bash everyone, so to speak, in suggesting that we're not handling any of those situations in the best ways possible given the system. But ultimately, I think that it creates a better atmosphere or a better milieu for us to be able to create the parameters for a culture around allowing young people to deal with problems on their own, and to create a means to be able to, I don't like to use this term police, but to certainly to manage their behavior and interaction themselves.